at the High Court, it would then appear that they are trying to cure defects in their response at the High Court by sneaking in this piece of evidence at this juncture. My view is that they ought to have sought leave, just like the way we did, to adduce that Gazette notice.
When was that affidavit filed?
That affidavit was filed yesterday, my lord, and it's dated 28th of June.
Did it comply with the times?
Yes, it complied with the timelines that the court had issued in respect to the response to affidavits, but our contention is that it does not respond to the JLAC report. It seeks to sneak in evidence that was not availed at the High Court. So in that respect, I'll be asking the court to expunge or strike out paragraph 5 and 6 of that affidavit, together with the Gazette notice that has been annexed thereof.
Not the entire affidavit, just paragraphs 5, 6 and the Gazette notice?
Correct, my lord.
I'm not sure whether we have even seen the affidavit.
Perhaps the court can take time, and it is dated 28th of June 2021. I believe it was filed yesterday by IBC. It is important for the court to look at those specific paragraphs before making a ruling on the same.
That's all?
Yes, in respect to the other affidavit sold by Dennis Waweru, it is a one-paragraph affidavit. It seeks to introduce a JLAC report on the referendum bill of 2020. Now, this is a bill that is distinct and separate from the BBI Constitutional Amendment Bill. It would then appear that this part of bill is being introduced to cover gaps in respect of the lack of legal framework in the processing of a constitutional amendment bill by way of a popular initiative. Again, it does not even seek to respond to the affidavit of Meroru Waweru on the JLAC report. It is just a new piece of evidence that is being introduced at this juncture. Again, it does not comply with Rule 29 of the Court of Appeal Rules. It is purely being brought again to improve their case. I note that the referendum bill that is being sought to be introduced, rather the report, is dated October 2020. Again, there was no reason as to why the BBI team could not have adduced this piece of evidence at the High Court. This, in our view, my lords and my ladies, amounts to trial by ambush, and it's a way of sneaking in evidence at the Court of Appeal and procedurally. That's all, my lord and my ladies. Thank you.
So can IEBC and BBI Secretariat just respond quickly?
If it may please, my lords and ladies, the response is really very simple. First of all, the responses were filed within time. Secondly, to the extent that the applicant on this issue sought and was allowed to adduce new evidence, it is not in their province to determine how the respondent should respond to that new evidence. The question of relevance is for the respondent to that issue, not for them as the applicant. More importantly, my lords, as indicated, they sought to introduce a report that was not before the trial court, the Justice and Legal Affairs Committee report. And as demonstrated, they did not produce the complete report. That report refers to an annexure, which is an additional report of the JLAC committee dealing with the referendum bill. That is the only report that is now produced in response to complete the new evidence that they have brought before this court. They cannot say it could have been produced before the High Court because they had not produced the JLAC report in order to complete it. Most obliged, my lord.
My lords and my ladies, on behalf of the IBC, first we want to associate ourselves with...
Sorry, this is for record purposes, Mr.
My name is Gumbo Eric.
Okay. Yes.
So my lords and my ladies, first I want to associate myself with submissions from learned senior counsel, Mr. Otiende. Secondly, I would want to point out that the issue of the annexure that is in our affidavit first is a gazette notice, which ordinarily would be a public document. Two, that in addition to that, the JLAC report that was filed with the leave of the court, and we did mention this in our replying affidavit, introduced a number of new issues. We didn't want to come and make that application again, that we respond to those new issues, which then would have had the effect of delaying these proceedings. The singular issue that that gazette notice responds to is just a confirmation of the fact that there's been indeed continuous registration of voters and nothing more. My lords and my ladies, if you look at the JLAC report itself and the Hansard that is with it, the deliberations that have been presented before you are of such a broad nature as to cover each and every aspect of the petition that is before you. In the event that we don't have that evidence or that gazette notice for purposes of responding to those issues, my lords and my ladies, we shall stand prejudiced. It is not introducing anything new. The question of continuous registration of voters has been before you. There's nothing new that has been introduced. That will be all, my lords and ladies.
Sorry, Counsel, can you connect the issue of the JLAC report and the continuous registration of voters? Let's get that connection clearly.
Yes, my lord. So what I indicated is that other than the JLAC report itself, we also had the Hansard, which was part of the document that were introduced with the leave of this court. The deliberations that went on, both which are contained in the JLAC report, as well as in the deliberations, are such as to cover every single spectrum that this petition is dealing with. So, to that extent, if we do not get an opportunity to respond to some of those deliberations, which will be available to the respondents for purposes of the proceedings that will be before you, then we'll stand prejudiced because we'll not have had an opportunity. And I said, my lords and my ladies, in our replying affidavit, we did mention that that was the risk that that leave was going to then place us in, because it was going to introduce issues which we thought we would not have had an opportunity to deal with. One of them is that question of registration of voters, because it is an issue that also was touched on if you look at the Hansard that was that supported the report.
Okay.
I'm most obliged.
In a brief rejoinder, my lord,
I would request, for purposes of recording, whenever counsel you stand there, just say your name, even if it is for the 10th time, because the transcription needs to record that.
Much obliged, my lord. My name is Elias Mutuma for the 19th, 20th, and 21st respondents in Appeal 291. In a brief rejoinder, my lord, in respect to my learned senior counsel, Otiende Amolo, the affidavit does not in any way state that they are seeking to introduce an annexure to the report that we had sought and was granted leave to adduce. In fact, the title of that document in itself does not even say that it is a replying affidavit. The title is that it is the appellant's further affidavit. If indeed that referendum bill was part of the Jail Act report, there was nothing that would have been simple than for them to state exactly that. We confirm that we filed a full report as received from Parliament, and the same is complete. As to the issue raised by the IBC, the court in its ruling was very clear, granting us leave, that the respondents were only supposed to respond to issues related to the production of the documents stated in our application, that is the Jail Act report. Now, the Gazette notice that is sought to be introduced has nothing to do with the Jail Act report. It was not an issue that was discussed by Parliament. It is not captured in the Jail Act report. We do not even intend to address the issue of voter registration through the Jail Act report. What is important, my lord and my ladies, is that the issue of voter registration was one of the issues that was active in the High Court. It is an issue that the High Court made a determination on. It was part of the pleadings by the petitioners. IBC had that opportunity to respond to that issue at the High Court, because again, the Gazette notice being sought to be introduced is not a new Gazette notice. It is dated 16th of September 2020. Now, these petitions were filed in December last year, so this Gazette notice was in existence before those petitions were filed. They ought to have introduced that piece of evidence at that time. That's all, my lord. Thank you.
My Lord the Mayor, on behalf of the 76th respondent.
To respond to the same.
Yes, my Lord, and the reason I've been constrained to get on my feet.
This is Mr. Poreko, Mr. Mukomi.
My name is Mukomi Nkolu, my Lord. And on behalf of the 76th respondent, who is Moraro Moke. My Lord, I would not ordinarily have stood, but the reason I'm constrained to come here is because this issue of voter registration was raised in the petition that Mr. Moraro Moke filed at the High Court. As you make your decision on whether the IEBC should be allowed to introduce a gazette notice showing that there has been continuous registration all along, my Lord, I will invite you to look at paragraph 769 of the judgment of the High Court. And the reason this is important, my Lord, in the High Court, the official position of the IEBC, according to that paragraph of the judgment, was that the last time the continuous voter registration was done was just before the by-election for Kibra constituency in the year 2018, about 3 years ago, my Lord. And now they are coming before you, having told the High Court that, to tell you, actually, we have been doing voter registration all along, and we have a gazette notice to show it. A gazette notice that was in existence at a time when they told the High Court a very different position. My Lord, we are asking you to note that. It's on the record. And for that reason, we will very humbly urge the Honorable Court to strike out that gazette notice. They are trying to close the stable long after the horse has bolted. Thank you, my Lord.
Now, the view of the court is that we want to give a short ruling at 11:30 when we return from our tea break. I do not know whether the issue relating to that affidavit and the gazette notice is one that is going to feature in Mr. Ogeto's address of the appeal. I don't think it is. It will come later. And if the issue will come later, we will then want to rule on it after we adjourn at 11.
Lords, to be of assistance to the court, this is not a matter that is featuring in our submissions, and we can proceed as proposed by your lordships and your lordships.
So just 1 minute. Briefly recorded that we shall make a ruling on the question of striking out the two affidavits as raised by counsel at 11:30 when we resume after tea break. So you may continue, Mr. Ogeto.
With the kind inductance of the court, my name is Kanjama, advocate, and I request to address the court before my colleague proceeds.
Mr. Kanjama, what's the issue? Mr. Ogeto, just take a brief, take a seat briefly.
I also seek to address the court on a separate issue.
Your microphone is not on.
My name is Charles Kanjama. I also seek to address the court on a separate preliminary issue, and I will be brief. My Lord, there have been three decisions of benches of this court on the question of who can participate in these proceedings. The first was issued on 2nd of June 2021, in which, in order number 2, all parties who had filed notices of appeal or intended appellants were given access to these proceedings, and this order was issued after I addressed the bench that was sitting on that date. My Lord, there was a ruling issued by a different bench yesterday, 28th of June, which allowed two amici who are not present in the proceedings in the High Court to also participate in these proceedings. And both of those rulings were facilitative of persons who intended to participate in the appeal. And there was a third ruling also issued yesterday, which restricted participation by myself in these proceedings and struck out a memorandum of appeal that had been filed by myself on the basis of two applications, one by IEBC and one by the Attorney General. The application by IEBC was never served upon myself, and the submissions that I prepared in response to the application by the Attorney General, I say seem with hesitation, seem not to have been considered by the court. Therefore, my lords, my ladies, I did file an application dated 28th of June seeking a second look by the court at the order that was issued yesterday. My lords, I note, my ladies, I note that my firm and myself have already been put on record in Appeal E291, which is the appeal that is proceeding, and pursuant to directions given by the Deputy Registrar, after the orders of this court of 2nd of June, we were requested to file a distinct appeal as an intended appellant, which is appeal number E307. And so there is a question that needs to be clarified as the court begins the hearing in regard to whether that appeal E307 shall be canvassed together with the other consolidated appeals. My lords, my ladies, when there is a momentous substantive appeal such as this one, the court also has a great opportunity to make momentous determinations on procedural matters that can clarify certain questions of procedure and law that the court has previously taken divergent views from time to time. And so we are urging the court to allow us to give a decision on this application and to allow us to submit on it. There are three issues that would be requesting the court to consider. One is the question of locus and right.
No, don't argue now.
Yes, I'm not arguing. I'm just mentioning the three issues, my lord, kindly. One is the question of, if that's okay.
Mr. Kanjama?
Yes.
The President says don't go into what your application is about until the court decides whether or not we will hear you. Perhaps it may be nice to respect that.
Precisely. And Mr. Kanjama, the bench, the presiding judge of the bench that heard your application yesterday, the Honorable Lady Justice of Kwengu, may have something to say regarding that application.
Most obliged. I'm sorry for having appeared to have disrespected the court. It was not my intention. I'm very sorry.
It's fine, Mr. Kanjama.
Thank you, Presiding Judge. Mr. Kanjama, upon receiving your request for review, we have checked and we do have communication from IEBC indicating that they served you with their application. We also have the replying affidavit which you have responded to, that you filed in response to the application by the AG. The application by the AG and the application by IEBC were in substance similar application. They were all seeking to have your notice of appeal struck out, and you denied the opportunity of appearing in this matter. So we believe that you are served because we have that indication from IEBC. We also believe that even if we are to accept what you are telling us now, that you are not served, and we are to review that order to the extent of setting aside the part that relates to the application of IEBC. I don't think it would change matters much, because there is already an order that is barring you, or rather not barring you, but restricting you from participating in this appeal. And that order, insofar as the Attorney General is concerned, you are not challenging it. So I think that what you are telling us now is really more of an academic exercise. It will not change the situation. Thank you.
So Mr. Kanjama, you have heard the view of the bench to which you have sought a review of yesterday's ruling. So we want to proceed with this appeal.
My Lord, could I very kindly just address the court on, for 1 minute on the procedural issue that is before you. I was just saying that yes, I have heard and I've respectfully listened to the directions that have been given. I however plead with the court, since I'm now before a 7-judge bench, to at least allow the applicant to articulate his application, because the application is not seeking to appeal against the decision of the High Court issued in March.
All right, Mr. Kanjama, since we are going to make a brief ruling on the other issue at 11:30,
yes,
we will also address your concern. So that will be at 11:30.
Could I request to address the court before it makes a ruling on my application? But I'll be guided.
No, Mr. Kanjama, there is an application in writing, and we know what you have said in your request for review. And so we will look at that supplemented by what we have so far heard from you. So I request that you take a seat and let Mr. Ogeto proceed. Kindly.
Most obliged.
My Lord. With your permission, my Lord, this is Professor Mika-Kech, amicus. With the permission of the court, kindly allow me to confirm that I filed and served my brief pursuant to the orders of the court issued yesterday. I also confirm that I'm at the disposal of the court. Thank you, my lords, my ladies.
My Lord, just very briefly, Elisha Ongoya here. I don't know whether my microphone is on. Thank you. Just very briefly, so that you give a direction together at 11:30. There is a direction in the ruling regarding admission of Professor Bbi Appeal.
I don't know whether your microphone is on. We can't hear you.
I trust I can now be heard. Thank you. My name is Elisha Ongoya. I represent the 74th and 75th respondents. And I address you regarding the...
Mr. Ongoya, perhaps you could give us the name of your client instead of just the number of the respondents.
Let me just pick...